Mr. Farenthold.
Thank you very much, and I'm really glad we're having this hearing today, as patent reform is an important issue. I'm kind of a tech guy, so I enjoy it. But you know, there's a problem when you've got, I can't get Wi-Fi at my local Whataburger, and the prices at my grocery store are coming up because they're getting tagged by frivolous lawsuits. So I kind of want to touch on some of the stuff that the gentlelady from California talked about, because I'm specifically interested in end users as well. And Mr. Gupta, you said that you don't settle unmeritorious suits because it would be tantamount to giving in to extortion. And I understand, as a player in the intellectual property game, that I applaud that. But, Whataburger, for instance, which, Texas-based burger company, better than In-N-Out Burgers, but they make hamburgers. They don't play in the intellectual property game, and they don't have the expertise in it. They get a demand letter, or you take it down even lower to a mom and pop business, and you get these demand letters listing all the demands, all the claims, all the potential damage, and then hitting you with 3 or 4 paragraphs on how to avoid a spoliation claim, and you got to replace the hard drives in all your computers to preserve evidence. I mean, does this go far enough to protect end users in what we're doing, do you think?
I think there are several provisions in the bill, and what you touched on is really a collection of abusive practices that lead to that sort of messy outcome for those defendants. And I think there are several provisions in the bill that would address very specific aspects of abusive procedural uses that would ultimately curtail those sort of behavior. But in the example of the burger manufacturer, if indeed it was something that they felt they needed to take a stand on, like Martha Stewart did, if they knew that ultimately, if they did take it to trial and they prevailed, that there would be some accountability on the part of the plaintiff for having harassed these folks in the first place, that there would be some sort of remedy at the end of the day to shift the burden.
So, Mr. Kappas, you talked about not wanting to reach down to the mom and pops. I think that was in answer to one of your questions. I mean, it seems like this stuff naturally rolls downhill once the patent trolls have finished shaking down the big businesses, and they move down to they've already moved down to the Whataburgers. I'd call them a medium-sized business. When do they move down to, the one person who has one retail store, the boutique, or when do they move into my house and say, "Oh my, you got a Wi-Fi router in your house and you got a cell phone. That'll be $50 licensing fee, or we're going to sue you for $10,000."
Yeah, so I think there are first of all, that is happening already, and that's why you've seen in some states some state action being taken. But there are a number of issues with this provision that I think for the Whataburgers of the world in Texas are going to make the provision probably not helpful in its current manifestation. The top one on my list is that there's a requirement for the covered end user or retailer in this case to agree to be bound by the judgment. The problem with that is that parties are never in exactly the same position. They're in different positions. They were put on notice at different times.
So what would you propose to fix that?
There needs to be work done on the statute in order to ensure that that parties.
But you would say a provision to stay it, then an option to be bound by it, and then tolling of the statute of limitations during that time. Would that be a workable solution? Or I'm trying to figure out how to fix this so it solves those problems.
Yeah, I'm not sure if I understand that, but certainly I think the issue is resolvable so that the statute benefits the retailers without being overextended.
All right, then does anybody else on the panel want to comment on ways we could improve that? And I'm specifically concerned about end user protection. Does anybody else want to add anything? I don't want to leave the opportunity. Go ahead.
I would say one other thing. There's an issue also there with the commonality of interest that's needed in order to trigger the provision, the way it's worded right now, I think we're going to see a lot of reordering of commercial relationships with parties, like the EMCs of the world when their customers are in asking to change indemnity provisions. That's going to create one set of situations because customers are going to want to get indemnities to get under this new provision and be able to stay litigation, and then EMC, when it's in the position of being a customer, is going to want to change indemnity language. And I'm not sure Congress meant to reorder commercial relationships, so that needs to be taken into account too.
All right, I see I'm out of time, but I think Mr. Kramer wants to answer if the chair will indulge me. Then let him answer.
Yes, you can answer.
Thank you, Mr. Chairman. Thank you for the question, Mr. Farenthold, Congressman. Yeah, I steadfastly believe that those who manufacture should stand behind their technology, right? I know we do. We expect our partners to do that. So I think the provisions in the Act regarding end user stays, I think, are a great start, and certainly happy to have my staff get in touch with your staff and work on appropriate language to make sure everybody is satisfied.
Thank you very much.